Hi, my name's Gary Fecto. I'm a Labor and Safety Inspector with the Maine Department of Labor, Bureau of Labor Standards, Wage and Hour Division. Today, I'm going to be talking to you about hourly wages, and hopefully this will help guide you through future employment opportunities, and at the very least, will help give you some information as to what to expect from your employer. That being said, we'll go to our first tile. So you're going to see a lot, Title 26, Chapter 7, that's the statutes that covers what we're going to be talking about today. And the basic points will be coverage posters, human trafficking, record keeping, minimum wage, overtime, timely payment of wages, final pay, overcompensation, unfair agreements, unfair contracts, and other major provisions concerning nursing mothers, equal pay, severance, and so forth. Some of these we'll skim over because they will be covered in future PowerPoints. So that being said, let's get going. Coverage in the state of Maine, and what requirements for any types of coverage. So family medical leave is in the state of Maine. Employees, an employer must have 15 or more employees to be required to participate with family medical leave. Earned paid leave, they must have more than 10 workers. And to be required to give sexual harassment training, there must also be 15 or more employees. Wage and hour laws are also governed federally, and their jurisdiction is slightly different than ours. Like they call theirs a Family Medical Leave Act, which requires 50 or more workers. In Maine, we adopt the law that will help the worker out more than the federal statute. And a good example of that is the federal minimum wage is $7.25, but in the state of Maine, as of January 1st, it's $12.15 an hour. So we enforce $12.15 because it helps out your common worker more. So what does work mean? Definition: to suffer or permit to work. What does employee mean? An individual employed or permitted to work by an employer. Who is an hourly employee? Also known as non-exempt employee. So most workers in Maine are hourly employees. We do have some folks that are salary exempt, meaning overtime exempt. There are special provisions for those types of employees, and you need to meet a special exemption, which is considered executive, administrative, and professional. Hourly employees are found in all industries: construction, manufacturing, all industries, hotel. There are white and blue collar jobs. So hourly employees are paid numerous ways, such as hourly, per diem, piece rate, salary, and commission. Salary's down there because you can be an hourly employee and get a salary. So that's kind of an oxymoron, but it's you're paid salary, but you're overtime eligible. The other one is your salary, but you're overtime exempt. There will be a PowerPoint that will explain that in the future, or any combination thereof. Minimum wage in the state of Maine is $12.15 an hour as of January 1st. However, some ordinances have been passed in different cities that may change that. So those ordinances would supersede the state minimum with, it has to be that their minimum wage exceeds and is not lower than the state average. The state minimum is $12.15. Portland, for instance, has a higher minimum wage. I know that Rockland is considering that, so that can happen. So minimum wage and hourly wage. Hourly wage must be at least minimum wage for the period paid. Can be a high hourly rate. There's no ceiling on that. Hourly wage is for all hours up to 40 in a 7-day cycle. Very important. Overtime is required for all hours over 40 in a 7-day period. Overtime is 1.5 times the regular hourly rate. The regular hourly rate includes additional compensation. Determining the overtime rate may require calculating the weighted average. Hourly rate may be decreased with 24-hour notice in advance. So if an employer wants to decrease your hourly rate, let's say you're getting $15 an hour, you're a construction worker, just for an example, but you have to travel 2 hours a day to and from a job site. He may want to pay you minimum wage while you're sitting in a truck traveling to and from work. You can do that, but because it poses somewhat of a hardship, they have to give you at least 24 hours notice anytime they change your hourly rate of pay. So what is regular rate? Regular rate includes all earnings, bonuses, commissions, and other compensation that is paid or due based on actual work performed. It cannot be less than minimum wage. Regular rate exclusions. Sums paid as gifts, payments for time not worked, reimbursements for expenses, discretionary bonuses, profit sharing plans, retirement and insurance plans, overtime, premium payments, stock options. Those would all be excluded. Work week. Minimum wage and overtime compliance is determined by the work week, not the pay cycle. So each work week stands alone. A work week is 7 consecutive 24-hour periods. So to give you an example, let's say your employer has a biweekly pay period and you work 45 hours the first week and 35 hours the second week. He can't give you an 80-hour pay. It has to be 40 hours regular pay the first week, 5 hours overtime, and 35 hours under your regular pay for the second week. So overtime always is geared to a 7-day period. So overtime rate is always 1.5 times the regular hourly rate or the weighted average. There are exceptions to overtime, like the salary overtime exempt worker would be one. Comp time only applies to public employees. State workers, we're allowed compensation time if we work overtime if we so choose, but it's not meant for the private sector. It's illegal for the private sector to use compensatory time. So calculating the regular rate and overtime. So it's pretty straightforward. If you have one rate of pay, it's pretty basic. You multiply your hours times your rate of pay. Any hours over 40 is time and a half. So your half rate would be your half hourly rate plus your hourly rate times the number of overtime hours. And that's basic. It gets interesting, but not difficult when you have multiple hourly rates. Like in this case, you have employee A, he works, let's say he works at a golf course and he's a maintenance worker and he gets paid minimum wage for that. But however, he works part-time also in a pro shop for the same employer and he's paid $15 an hour. So how do you figure that? That's 47 hours. So how do we get to the overtime weighted average? It's pretty straightforward. We would multiply his hours worked times the minimum wage to get the $255.15. Also, the hours worked time in the pro shop times his $15 an hour rate would give us $390. Added together, $645.15 would be his straight time earnings. Pretty straightforward. Now, to get the regular rate, we take that $645.15, his total, divided by his hours, the hours that he worked, will give us the regular rate of $13.73. Now we got to figure out the halftime rate. So we take the $13.73 and divide by 2. We come out with $687. That is our halftime rate. So $687 times 7 hours, which are the overtime hours, comes out to $48.09. $645.15 plus $48.09 comes to $693.24, and that's what he would be owed. Pretty straightforward. So here's an example of the hourly rate with a production bonus. So the total hours the employee works is 48 hours. His hourly rate is $12.15, and he got a bonus of $50. So we would add, so that bonus, because it's for production, is going to affect his overtime. So we take the hours that the employee works times his rate of pay will give us the $583.20, plus the bonus will give us the $633.20. Divide that by the 48 hours that he worked, and that gives us his regular rate. Divide the regular rate of $13.19 by 2 will give us the half rate of $660, times his 8 hours overtime will give us the $52.80. That's the halftime wages owed. And his total plus the halftime wages owed come to $686 total wages owed. The wage and hour, the federal wage and hour division also, they have an overtime calculator, and this is where it can be found. Limits on mandatory overtime. So there are limits, and it's in a 2-week period. Law requires that an employer cannot require employees to work more than 80 hours overtime in a 2-week period. So that applies to hourly employees. So that means that's 160 hours in a 2-week period. That doesn't apply to salary overtime exempt workers, as those workers can be required to work 24 hours a day. There are overtime limit exempt, and that, as I just spoke, the salaried employee, and also some seasonal workers. Compensation requirements, wages, law section 663.5. So that requires all forms of compensation, automated pay card requirements and fees, municipal volunteer firefighters, pay cycles, public employees, service employees, and more than $30 a month in tips. Employment records, records to be maintained by the employers. Employers are required to keep true and accurate records. They have to keep records of the dates the employee works, the amount they were paid, has to be kept daily. They obviously don't have to keep those records for the salary overtime exempt workers. Hours worked must be displayed on each pay statement, and it must be accessible for DOL inspection, and also it must be accessible to the worker at all times. So they always must have access to their pay statement. Timely and full payment of wages continued. So regular payment is required on an established payday, which means the employer has to pay the worker on a routinely established pay cycle at regular intervals made known to the employee. So if you're paid every other Friday, you have to be paid every other Friday. If you're paid every 15th and 30th of the month, you have to be compensated every 15th and 30th. It's not at the employer's discretion to change this unless they provide advance notice. Increasing intervals between pay dates requires a 30-day written notice in advance. So for instance, if the employer goes from a weekly pay cycle to a bi-weekly pay cycle, that poses a hardship to the worker, as that worker is used to getting a weekly pay, but all of a sudden now they're going to be getting it every other week. So that requires a 30-day written notice in advance. Lowering the rate of pay requires a 1-day advance notice. We've already spoken about that. School personnel, if employee works the school year schedule, he may be paid over 12-month period or shorter. It's at their discretion. Must have written agreement, includes but not limited to collective bargaining agreement. A lot of schools have unions. Volunteer firefighters must be paid at regular intervals, not to exceed 6 months. Timely and full payment of wages, minimum frequency and full payment. Regular intervals not to exceed 16 days, must include all wages earned to within 8 days of the payment date. Cessation of employment. An employee leaving employment must receive pay for all hours worked, vacation pay in accordance with company policy, earned paid leave in accordance with company policy, be paid in full no later than the employee's next established pay date. Overcompensation may be withheld if authorized under 635. If employee voluntarily terminates employment, the employer may deduct the full amount of the overcompensation. So loan or advances may be deducted. Remedies for unpaid wages, sale of business pay liability. So let's say the employee borrowed money from the employer and it's his last pay. The employer has the right to withhold that amount from his pay to recoup what he lent the worker. Overcompensation, namely the recovery. How does an employer recover overcompensation? Because it is a hardship on the worker, the employer, unless the employee agrees, the employer cannot recover more than 10% of the employee's net check amount on a pay per pay basis. Violations, employers with over 25 employees, the coverage knowingly accepted overcompensation. So even if the employee knowingly accepted that overcompensation, the employer still can't recoup more than 10% of the net amount of the employee's future checks without that employee giving permission for the employer to withhold more. Unfair agreements. You can't work without compensation. The employer can't make deductions for debt, benefit to the employee, or not. So there are certain things that are considered costs of doing businesses in certain industries. Those employers can't charge those workers for that. Like someone working in a convenience store and somebody walking out stealing something, that employee can't be charged. The worker, working in a convenience store can't be charged for that theft. Deductions for service fee allowed public employees, they can't do that. Collective bargaining agreements. Reimbursement of arrears cannot exceed in each pay period 10% of the gross pay owed. Court-ordered wage garnishments, and employer can deduct processing fee of $2 in those instances. And unfair contracts. No employer shall, by a special contract with an employee or by any other means, exempt him or herself from any part of this regulation. And that means minimum wage, overtime, record-keeping requirements, all requirements of the employer. Rest breaks. So there's a common misconception amongst workers in that you're supposed to get, if you work an 8-hour day, you're supposed to get a 15-minute break in the morning, a lunch break, and then a 15-minute break in the afternoon. And that's a common misconception. The 15-minute breaks, those are not required by law. The employer certainly can give you those breaks. They're not a requirement. The only requirement is that any employee that works over 6 consecutive hours must be afforded at least the opportunity to take a 30-minute uninterrupted break. And it may be used during mealtime, it may be paid or unpaid. So any break over 20 minutes, the employer can make the employee punch out. Under 20 minutes is on the employer's time. They cannot make the employee punch out. So exceptions. Doesn't apply to emergency situations in which there's danger to property, life, public safety, or public health. Does not apply to small businesses when fewer than 3 employees or duty at same place and same location, and nature of the work allows frequent breaks. So good example is the overnight convenience store worker. Less than he or she's alone, but is allowed a lot of periods where nobody's in the store and sitting idly, so they have plenty of opportunities to take breaks. New and amended laws, tip pooling. Tip pooling can only involve service employees, and there will be a future PowerPoint that will address this issue completely. Again, tips can only go to service employees. Tip pooling is where an employer collects the tips and distributes them out evenly amongst the service employees, as opposed to each employee keeping their regular, whatever tips they would get at their respective tables. Severance pay. Notice requirements increased from 60 to 90 days. And penalty for the employer is $500 per day. So compensation history. An employer may not use or inquire about the compensation history of a prospective employee from the prospective employee or a current or former employer of the prospective employee unless an offer of employment that includes all terms of compensation have been negotiated and made to the prospective employee, after which the employer may inquire about it or confirm the prospective employee's compensation history. School personnel, 621-A. This law requires a school administrative unit to provide school personnel who are paid on an hourly basis with the option of receiving pay over a period of 12 months or shorter. Prospective employee's Social Security number under 598A. An employer may not request a Social Security number from a prospective employee on an employment application or during the application process for employment except for the purposes of substance abuse testing under subchapter 3-A or pre-employment background checks. This section does not apply to employers' requests for a Social Security number after the employee has been hired, obviously for tax purposes. Apprenticeship in energy facility construction, we'll touch briefly on this as it won't apply to a lot of individuals. Construction employers shall, to the extent qualified apprentices are determined to be available in accordance with the rules adopted by the department, employ a number of apprentices that equals to at least 10% of all persons employed in the construction, 17.5% of all persons employed in the construction if construction of the generation facility begins anytime between 1/1/2025 and 1/1/2027, and 25% of all persons employed in the construction if construction of the generation facility begins anytime on or after 1/1/2027. Earned paid leave came into effect this year, January 1st, 2021. Who is affected and who's required to offer earned paid leave? So earned paid leave, any employer that employs more than 10 employees in the state of Maine for over 120 days in any calendar year is required to offer earned paid leave. Earned paid leave includes all employees, full-time, part-time, temporary, per diem, all workers. What does it offer? 1 hour of earned paid leave is accrued for every 40 hours worked, up to 40 hours in a defined year. An employee can accrue more than the 40 hours, but that's at the employer's discretion. The law only requires that employers accrue up to 40 hours. Employees can use up to 40 hours in any defined year. Employers can apply a 120-day waiting period before new employees can use their accrued earned paid leave. Earned paid leave can be used for any reason, such as emergency, illness, sudden necessity, planned vacations, etc. Employer can require the use in 1 hour increments and may choose to allow the use of leave in smaller increments. So it's at the employer's discretion. The law says that the employee can use as little as 1 hour at a time. The employer may choose to allow less than 1 hour at a time to be used. Again, that's at the employer's discretion. Non-compete agreements, pretty simple. An employer may not require or permit an employee earning wages at or below 400% of the federal poverty level to enter into a non-compete agreement with the employer. The 2021 federal poverty level is $12,880. For 400% of that amount is $51,040. So an employer shall disclose prior to an offer of employment that a non-compete agreement shall be required, but you can't require it for anyone earning less than $51,040. Restrictive employment agreements. Basically, employers can't get together and restrict each other from hiring certain individuals. There's a large minimum penalty for that, and it's simply not allowed. Firefighters, EMS workers, search and rescue personnel. Absence for emergency response, firefighters and EMS. It prohibits an employer from taking disciplinary action against an employee for missing work because the employee was responding to an emergency in the capacity of a firefighter or emergency medical services person, and the employee reported to work as soon as reasonably possible after being released from the emergency. Pretty straightforward. Absence for emergency response, search and rescue volunteers. Allows an employee that is certified in search and rescue operations to report to work late or leave work early as a result of responding to a search and rescue operation as a volunteer. The wage theft remedies includes a violation of the following law sections: timely and full payment of wages, record keeping requirements, cessation of employment, unfair agreements, fringe benefits, minimum wage, and overtime. The Wage and Hour Division can issue a cease operations order if the employer committed wage theft or the employer's practice or policy has resulted in wage theft on more than one occasion or within the last 12 months, and the wage theft affects 10 or more employees, or B, the wage theft is equal to or greater than twice the employee's average weekly wage. So if the offense is egregious enough, the Wage and Hour Division has the right to issue a cease operations order on any business in the state of Maine. Leave for appointments for veterans. Employers must allow veterans to take time away from work to attend scheduled appointments at a VA hospital. Employer must allow employee to use paid sick leave if there's any available. If paid leave time is not available, employer must then grant unpaid leave. So leave must be granted at all costs. Public Works, and this applies to prevailing wage, and we're not going to touch too much on this as we have a coordinator that handles, a labor inspector that handles prevailing wage in the state of Maine. Public work includes public schools and all buildings, roads, highways, bridges, streets, alleys, sewers, ditches, etc. Basically any building that is under construction that is considered public works, there is a prevailing wage in each county that determines what that construction company has to pay each position, each occupation. Employment posters. So as a labor inspector, my job is to go into businesses in different towns in my jurisdiction, inspect the business, and one of the requirements is they have to have these posters displayed. And they have to be displayed in a common area where their employees have access to at all times while they're at work. And those posters must include regulation of employment, minimum wage, employment of minors, Whistleblowers Protection Act, sexual harassment, human trafficking awareness sign, and video display terminal safety. As I stated earlier, there will be additional trainings available in these areas: salary exempt employees, tip service employees, child labor and work permits, regulations of employments that don't relate to pay. Any questions or comments? You can reach us. This is our contact information. We have our website, and also we have someone available 5 days a week from 8 to 5 at 623-7900. That's available every day to answer any questions that you may have. Thank you, and you have a great day.